Hey, Deja.
Yeah?
I can tell you a dad joke.
Okay.
Why did the coffee file a police report?
Why?
It got mugged.
Please stick with the Moneywise FAQ.
Come on, I mugged you with the dad joke. Oh, fine. Moneywise FAQs are better.
What kind of things do employers or business owners need to know about court order garnishments, child support orders, tax liens, things like that? What would you suggest?
First and foremost, don't throw those things away. They are court ordered and you're required to do the withholding. Secondly, you should let your employee know, but don't let your employee talk you out of not withholding it. Free to give the employee time to try and sort it out with the court, but unless you receive a letter directly from the agency saying this has been resolved and you're under no obligation, you need to do the withholding. Unfortunately, in this case, the employer, whether we agree with it or not, the employer is acting as an agent of the court or the Department of Child Services or the Department of Taxation that's seeking this money, and the employer needs to hold the responsibility as that agent of the other agency in high regards, because if they don't, it's the employer who can ultimately be on the hook. So really, the beginning of this is don't mess around with these orders, take them seriously.
How do you know what to withhold or how to calculate? Because I know they come with all kinds of different stipulations and directions. They can get very tedious.
They can get very tedious and very complicated, and every agency is different. There are some laws, and in the state of Virginia for child support, as an example, if you have one child that you have child support, you're allowed to take up to 50% of their disposable income, and that increases in 5% increments based on whether or not the case is in arrears or if there are multiple children. For garnishments, there are federal levels. It's based on 25% of the disposable income, and your disposable income is your gross pay minus your taxes, and that's indexed to the current kind of national minimum pay levels, and that minimum amount is indexed to kind of a national level of minimum pay. There is an amount under which an employee makes so little for some kinds of things where nothing can be withheld on those. That's okay, you just need to have the records to prove it. And then tax liens, there's a whole host of different things, right? If it's an IRS levy, somehow that's calculated is based on what the employee filed on their actual tax return in the last tax year. For times when maybe it's a student loan payment that your arrears on your student loans, that's 10%. Other tax liens in Virginia, unless you claim hardship, they're able to take 100% of your net pay if you owe taxes. So carefully read the notice. As an employer, you should get your own copy of the notice. It shouldn't come from the employee. You should get your own copy of the notice. Carefully read it and understand what that particular agency is asking for in terms of what can be withheld and what can't be withheld.
If there's any question, would you just suggest they call the court?
Yeah, call the agency in question, right? If it's a child support question, there should be a number on there that says for questions, call. I would call the agency in question. And I would also make sure that you're sending the money to the agency in question. Some agencies allow you to send checks. Some agencies require you to send checks. Some agencies allow for online or ACH payments. That's very common now with child support. Some agencies have a due date. Oftentimes you'll see this in a court case. If it's a small claims court garnishment order, there's a due date. That due date is the next hearing. You just want to make sure that all of those payments reach the court before that hearing date. And that hearing date is also the date at which no more money can be withheld, whether or not the employee has had enough withheld to satisfy that garnishment. If there's still an outstanding balance, it's the court's job and the garnishor's job to issue another garnishment at that point.
We get asked a lot too sometimes, can the employee pay more than what's on the garnishment or on the court paper?
Sure, this is true. The employee can pay more. That actually is good for the employee, right? But the employee can't be forced to pay more. So you want to be careful with any of those separate agreements and arrangements that it is clear that it's an agreement and arrangement, because if you withhold more from the employee and you didn't get it in writing that the employee said it was okay to withhold more from the employee, and then the employer later complains that you withhold incorrectly, you can be responsible for that mistake, even if it wasn't a mistake. So any separate arrangement, you want to be careful of how you handle that. If you have questions about this or any other payroll-related issues, subscribe to our newsletter from our website or follow any of our socials on Instagram, LinkedIn, or our YouTube channel.
Feel free to give the office a call or stop in. We're right in downtown Charlottesville. Any one of us can answer any questions you have.
My name's Sean,
This is Bobby.
and this has been a Moneywise FAQ.